It is a real privilege to chair this panel today. I'm surrounded by very esteemed legal professionals, whom I will introduce in a second. And I'm particularly excited also personally about the subject matter that we will be dealing with this afternoon. So first, the title of this panel, Independent Administrative Discretion and the Rule of Law, brings together three fundamental concepts: independence, discretion, and the rule of law. And put together, they pose a fundamental question that lies at the heart of many contemporary debates. What is the role of independent administration in a legal order based on the rule of law? To what extent should independent bodies be given discretion, and where should the limits lie? Now, the second reason why I find this panel so compelling is its comparative perspective. The panelists will explore developments in both the European Union and the United States to help us uncover shifts in how independent institutions are understood and challenged in modern legal systems. Are there key differences in how the two legal orders approach this issue, particularly in the view of their highest courts? Are the two systems more similar than they might initially appear? Are there shifts in their respective developments? At a starting point, there are two possible opposing perspectives on independent administrative discretion, and they reflect very different worldviews. The first view argues that independent administrative discretion should be tightly controlled or even eliminated altogether. And according to this perspective, the only approach consistent with popular legitimacy is strict oversight of independent bodies by a strong president or the courts. And across the Atlantic, this view seems to gain currency, and we are seeing growing mistrust of independent institutions and independent discretion. Now, this mistrust comes from various directions. Just past February, an executive order gave the White House greater control over independent federal agencies that have traditionally operated outside its direct supervision. And I'm sure that many of you have followed with great concern, I might add, the recent developments surrounding the dismissal of Governor Cook. And the Supreme Court has added to this trend. Last year, it overturned the Chevron deference doctrine, which for 40 years had directed courts to defer to an agency's reasonable interpretation of ambiguous statutes. Chevron was a cornerstone of modern administrative law based on the pragmatic assumption that lawmakers intentionally delegated authority to agencies to fill the gaps. Now, on the other hand, there is another perspective, one that views independent discretion as not only compatible with the rule of law, but as a vital part of it. And from this other perspective, independent bodies are essential for good constitutional governance. They provide reliable statistics, to give you an example. They enforce environmental regulations, and they protect fundamental rights. After all, agencies are not only insulated from short-term political pressures, they also have expertise and are closer to the day-to-day realities of regulation. And far from undermining the rule of law, their discretion can actually enhance the rule of law by protecting minorities, by protecting long-term goods such as the environment, and by providing expertise-based deliberation. Their accountability and review by courts can be ensured without reducing them to mere arms of the executive. And courts can calibrate a standard of review that ensures legality and the protection of individual rights without appropriating the discretion awarded to the administration by the legislator. And this leads us to the question, where does Europe stand in this debate? And to help us answer that, we have three distinguished panelists who will provide valuable insights from both a European and a US perspective. First, Advocate General Nicolas Emiliou will share the European perspective. Advocate General Emiliou, appointed to the Court of Justice in 2021, has a distinguished career in academia, diplomacy, and government. And today, he will discuss the Crédit Lyonnais case, in which he authored a truly remarkable opinion. And this opinion not only addressed critical issues for the European Central Bank, but also offered a masterful analysis of the broader questions that we are tackling right now today. Next, Pedro Machado will provide insights into the importance of independent administrative discretion within the single supervisory mechanism, the SSM. And Pedro has over 20 years of experience in financial regulation and supervision, and he is currently a member of the SSM Supervisory Board. And he will also introduce the US perspective, explaining how differing constitutional principles, separation of powers in the US versus institutional balance in the EU, shape the role of independent discretion. Importantly, he will highlight why supervisory discretion is crucial for qualitative measures, escalation, and the enforcement in the ECB supervisory framework. And finally, Professor Mariolina Eliantonio will take us deeper into the doctrinal questions. As a professor of European and comparative administrative law at Maastricht University, her research focuses on shared administration, environmental law, and new modes of governance. Today, she will explore whether the EU and the US models are as far apart as they seem, or whether they are actually converging in maybe unexpected ways. Together, our panelists here today will offer a comparative perspective on the evolving role of independent discretion in legal systems founded on the rule of law. And they will not only shed light on the theoretical aspects of this issue, but they will also help us understand its practical implications. I very much look forward to that thought-provoking discussion. And I also invite you to already start thinking now about your contributions to the debate, because I will, of course, cater for as lively as possible an interaction after the three first presentations. So, Advocate General, please, the floor is yours.
Thank you. First of all, I'd like to thank the organizers for their invitation. It's a pleasure for me to be here. We'll start by saying a few things about the rule of law and the EU legal order in general, and then I will deal mainly with the question of intensity of judicial review by the courts of the European Union. As you know, Article 2 of the Treaty on European Union enumerates the rule of law as one of the fundamental values upon which the Union is based. It is a multifaceted principle, but one branch of this principle is the fact that the acts of public powers are subject to judicial control. It is well known that the principle of the rule of law did not expressly feature in the original community treaties. As usual, it was for the court to come in and fill the gap. In the well-known Loper case in 1986, the court held that the then community was a community based on the rule of law, inasmuch as neither its member states nor its institutions could avoid a review of the question whether the measures adopted by them were in conformity with the treaty, which the court characterized as the basic constitutional charter of the community. This ruling should be seen as a part of a broader set of judicial decisions, both prior and subsequent, such as Van Henden, Loss, Costa and Enel and Frankovic, in which the court reinforced the capacity of EU citizens, undertakings and associations to take action before a court to claim rights they derive from EU law, regardless of the author of the breach. In short, these cases mean one thing, that in the European Union legal order, the principle ubi ius ibi remedium, that is, wherever there is a right, there is a remedy, is prevalent. So the role of the courts is crucial within the EU institutional setting. In particular, their function to review the legality of measures adopted by decision-making institutions. In the EU legal system, judicial review of acts adopted or failure to adopt them by the institutions is mostly centralized, being one of the main areas of jurisdiction conferred on the Court of Justice by the drafters of the treaty. In particular, it is the court under Articles 263, 265, 267, and 277 of the treaty that reviews the legality of action or inaction of the institutions, and under Articles 268 and 340 hears actions for damages based on the union's non-contractual liability. As far as judicial review of legally binding acts adopted by the institutions or bodies or offices or agencies of the union, the scope of the review of the court is clearly set out in Article 263, which refers to actions brought on grounds of lack of competence, infringement of an essential procedural requirement, infringement of the treaties or any rule of law relating to their application or misuse of powers. In essence, this means any infringement of a superior rule of law, of a procedural or a substantive nature. To my knowledge, this part of the treaty provision has given rise to relatively few issues before the court or in academic fora. By contrast, the treaties have been silent with regard to the standard of judicial review to be applied by the courts. What I refer to is, in essence, the intensity of the review to be carried out by the courts when reviewing the legality of an act under challenge. From another perspective, the standard of review can be regarded as being the degree of deference accorded by the court to the institutions which adopted the acts under review. Obviously, the higher the level of review, the lower the degree of deference according to decision-making institutions and vice versa. Quite clearly, this is by no means an issue that is peculiar to the EU legal system. As I noted in my opinion in the Lyonnais case, questions concerning the limits to judicial control of legislative and administrative action have arisen and will continue to arise in every legal system. Indeed, I can hardly think of a legal system that could function properly, at least from the vantage point of today's Western democracies, which are founded on the principles of separation of powers and institutional balance, if the judiciary were empowered to set aside and substitute every decision taken by the other public institutions on any ground. Just to give a very obvious example, the issue has very recently been put back on the spotlight in the United States, where the Supreme Court, in a ruling on the 28th of June 2024, has overturned the well-known Chevron doctrine, as mentioned by our colleague. Coming back to the EU legal system, I would like to share with you some thoughts that I developed in my opinion in Crédit Lyonnais. That case offered to me the opportunity to discuss in detail the standard of review that, in my view, the EU courts should apply when assessing the legality of acts adopted by EU institutions, enjoying a margin of discretion. In that opinion, I first attempted to clarify the legal framework applicable in this area, and in doing that, I also focused on certain legal concepts that are, in my view, quite often misunderstood. In the opinion, I have argued, among other things, that in the EU legal system, the intensity of judicial review depends on a number of factors. First of all, on the specific characteristics of the act whose judicial review is sought. The intensity is the highest full review with regards to the establishment of simple or primary facts, because those can either be true or false. In addition, EU institutions other than the Court of Justice may have some leeway in applying EU rules, but not in interpreting them. Indeed, it is for the Court of Justice as the supreme interpreter of EU law to speak the law. There is one oracle of law in our system, and this is the Court of Justice. However, according to well-established case law, some deference to the EU institutions by the Court is granted where they enjoy a degree of discretion in applying the relevant provisions. In that regard, it seems to me, generally speaking, two broad categories of discretion can be identified, although I'm aware that in academia there are different views in that regard. The first category is that of policy discretion. That is the case where the applicable provisions grant expressly to the EU institutions concerned some latitude in choosing whether or how to act in certain circumstances on the basis of relevant policy considerations. The second category is that of technical discretion resulting from EU provisions that require from the acting institution a complex technical assessment before the adoption of a given act, that is economic or scientific considerations. In that regard, I wish to clarify one element. In my view, an assessment is not complex simply because the establishment of the relevant facts is not straightforward, requiring instead a difficult, time-consuming, a specific knowledge-driven process. Indeed, it would be odd to think that judges may refrain from granting effective judicial review to individuals each time a case is, from a factual point of view, not clear-cut. In my opinion, a complex assessment is only where the relevant factual background cannot be established objectively or with absolute certainty, since reasonable and well-informed people could, at least to some extent, disagree on the outcome of the fact-finding exercise or the legal qualification of the facts. That may be the case where the institution in question is required, like the case here of you in the ECB, to make use of some models or assumptions in order to infer from a set of facts certain complex conclusions, or to make value judgments to qualify the facts and determine the resulting legal consequences. The case law of the court is rather clear, however, that in both situations, the EU institutions concerned should be accorded some latitude. In particular, the institutions must be accorded broad discretion in areas where their action involves political, economic, and social choices, and where they are called upon to balance policy considerations. In those cases, the validity of the measures adopted by the institutions can be affected only if they are manifestly inappropriate in view of the objective which the competent institution seeks to achieve. In addition, in case of complex technical assessments, the court has consistently held that judicial review is, and I quote, confined to verifying whether the rules on procedure and on the statement of reasons have been complied with, whether the facts have been accurately stated, and whether there has been any manifest error of assessment of the facts or misuse of powers, end of quote. These two strands of case law, despite some terminological differences, appear to have an important element in common. With regard to the merits of the Challenge Act, the EU Court is allowed to censure the institution in question only in the event of manifest errors. These strands of case law have given rise to some criticism. Some observers have taken the view that the court can only perform marginal review of legality of the challenged acts under these circumstances. However, this is not the way I read the case law. In fact, I find somewhat unfortunate the use of term manifest in that context, as it may convey the incorrect idea that errors that are not sufficiently obvious will not be censured by the court. As I see it, the term manifest must be understood with reference to the duty of the applicant to prove to the required standard that the evaluations or analysis carried out by the institution in question were unreasonable, or the conclusions reached implausible. Indeed, where an institution enjoys some discretion as to how a rule should be applied, there is a larger or narrower, depending on the circumstances, range of options which it can legitimately choose from. Thus, an error of assessment exists only where the institution in question chooses a course of action that falls outside the range of permissible choices under the law. Accordingly, as long as the institution that adopted the challenged act did comply with the relevant procedural rules and with regard to the substance remain within the boundaries of the discretion accorded to it by the relevant EU rules, the court will not and better cannot review the choices expressed in the act. In other words, the judges cannot decide what would have been, in their opinion, the best course of action for the institution concerned under the given circumstances. Judicial proceedings are generally ill-suited for any form of ex novo review of legislative or administrative action. Moreover, an excessively intrusive form of judicial review would encroach upon the margin of discretion accorded to the institutions to exercise their powers effectively, thus conflicting with the principle of conferral of powers to the institutions and upsetting the principle of institutional balance. However, it must be acknowledged that determining in each case the exact boundaries of the permissible discretion enjoyed by an institution, and as a consequence the intensity of judicial review, may at times be a very delicate task. The latitude enjoyed by an institution when taking a given decision obviously varies from case to case, depending on a number of variables. The most important of these variables are, in my opinion, the following. First, I think that the EU institutions should be granted more leeway when they act in their legislative capacity than when they act in the context of their administrative functions. Second, case law suggests correctly, I believe, that policy discretion should generally imply general latitude for the institution concerned than mere technical discretion. Third, the margin of discretion accorded to the EU institutions also depends on the wording and objective of the relevant provisions. It is indeed the EU constitutional or ordinary legislator that through the adoption of the relevant legal provisions delegates certain powers to the institutions and determines the limits of those powers. Fourth, the intensity of review of the exercise of discretion must also depend on the nature and level of interference with the right invoked by the applicant. For example, as the court has held on many occasions, and I quote, where interferences with fundamental rights are at issue, the extent of the relevant EU institutions' discretion may prove to be limited depending on a number of factors, including in particular the nature of the right at issue guaranteed by the Charter, the nature and seriousness of the interference, and the object pursued by the interference. End of quote. Last but not least, it seems to me that the legal and factual context in which an act is adopted may also have an influence on the margin of discretion enjoyed by the institution in question, and consequently on the court's review of the actual exercise of this discretion. I suppose following these thoughts, some of you may wonder what does the above mean in concreto for institutions and authorities that enjoy, on the basis of relevant legislation, or even as it's the case of the European Central Bank on the basis of primary law, a significant degree of independence. Should the judges accord to such institutions and bodies a higher degree of deference or not? Clearly, arguments of principle may be made in both directions. On the one hand, a lesser degree of intensity of judicial review could be considered consistent with the intention of the constitutional legislature to enable those entities to operate autonomously, shielding them from any form of direct or indirect influence from external actors. On the other hand, however, it could be argued that strict judicial review is even more necessary given the fact that there is little political control, especially from the institutions which express directly the democratic choices made by the EU citizens. I hope that you do not see this as anticlimax, but my answer to that question, which would certainly merit more detailed intervention well beyond the scope of the present one, would be again, it depends. It all depends on the specific situation. Coming back to the legal framework that I described above, I would say that the main variables in this equation are three. First, the nature, content, and effects of the challenged act. Secondly, the scope and purpose of the provisions granting the institution the power to act. And thirdly, the specific legal position of the individual affected by it. This is valid for acts of the European Central Bank, just as it is valid for acts of any other institution. Accordingly, I do not think that independence, whatever the term is understood to me, warrants by itself a higher or lesser degree of judicial review. The relationship between independence, accountability, legitimacy, and intensity of judicial review is very interesting indeed, but I prefer to leave it to a scholar like Professor Antonio. Seen from the bench, there is no a priori deference or by contract stringency in the approach followed with respect to acts adopted by independent institutions or bodies. Judicial review is carried out with the usual diligence, whilst the court being as always mindful of the key principle of separation of powers and institutional balance. Also, I do not think there is a single standard that applies horizontally regardless of the area in which the ECB acts and the nature and content of the challenged act. For example, some observers have suggested a form of judicial review that would consist, in essence, in a control of rationality of choices made by the acting institution, a standard that is between full review and full discretion. I'm not sure this is the way I would approach this subject. To me, it is obvious that the standard of review to be applied by the court in decisions which involve policy choices, such the one as at issue in Pringle or Gauweiler, cannot be the same with that to be applied in case where individual decisions on prudential issues are adopted, such as that challenging Lyonnais or other similar cases. However, it remains true that in both types of cases, it is not proper for the court to make a fully fledged and ex novo assessment of the matter. I know that we have talked about complex issue. I hope that this intervention has provided some elements on reflection on this very complex matter indeed. Thank you very much.
Thank you so much, Advocate General. I will go to Pedro now, but not before saying that maybe it's good for all of you that are not always in this building to realize how many decisions are actually made every day in this building that will all one way or the other fall within this discretion and and this standards that the Advocate General has just spoken about. Fit and proper decisions, decisions on authorizations, decisions on share buybacks. I mean, I don't know. I've never counted them, but there must be hundreds a day if you think about all the banks that we have. So it is not just theory. It's very, very relevant for the work that we do. Pedro.
Very much. And first of all, it's really a pleasure to share this panel with such distinguished members, in particular, to be in a conference and seeing so many friendly faces from the long past and also the recent past. So thank you very much, in particular to Chiara, for inviting me. So, in order to contribute to today's panel on independent administrative discretion and the rule of law, I would like to share some reflections which are grounded in banking supervisory discretion. And at the same time, I will try to engage in a short transatlantic comparative exercise, which then I understand that Mariolina will develop. So when we speak about banking supervision, we often focus on rules, ratios, and reports. But behind every rule, ratio, and report in banking supervision lies something which is far less visible, but not less decisive, which is discretion. The judgment supervisors must exercise when facing complex, fast-moving, and often uncertain situations. In the European Union, supervisory, and in particular the banking union, supervisory discretion is tied to the independence of the ECB within the banking union, safeguarded by accountability and judicial review. The EU standard of review, which is reflected in settled case law, as we've just heard, is built on judicial deference to technical discretion, but subject to clear legal and procedural limits. In the United States, by contrast, for 40 years, the Chevron doctrine, which we also heard about, granted agencies wide interpretative authority, until last year's landmark Loper Bright decision overturned that deference standard. The Supreme Court now insists that judges, not agencies, must interpret questions of law exclusively, thus quashing the practice of judicial deference in the face of statutory ambiguity. The European model of deference to technical expertise and the American model's retreat from agency interpretation invite us to reflect on how independence, accountability, and judicial scrutiny can be reconciled in practice. For this, I will start with the European perspective. So the political choice underpinning the supervision pillar of the banking union was to grant an independent institution, the ECB, powers and responsibilities to supervise European banks. The transfer of these powers and responsibilities from national to EU level was tied to the independent exercise of supervisory powers. The German Federal Constitutional Court, in its judgment on the banking union, examined the tensions that the ECB's independence raises in relation to democratic legitimacy under the German Constitution, in particular as its supervisory tasks come on top of its monetary policy mandate. In the court's view, this tension is, and I quote, compensated by specific safeguards that serve to ensure democratic accountability in relation to the supervisory tasks and powers entrusted to the ECB. These safeguards in the SSM regulation notably include strict judicial review of the ECB's actions in that domain, specific national parliamentary oversight rights, and accountability of the ECB to the EU institutions that have transferred tasks and powers to it. Accountability through democratic oversight and scrutiny, paired with judicial review, constitutes thus the backbone of the ECB's independent exercise of supervisory powers. As a result, it is, I think, legitimate to argue that the ECB enjoys broad discretion when performing its supervisory tasks, as the German Constitutional Court explicitly underlined. So supervisory discretion should there be seen as a fundamental tenet of the ECB's role. In European law, administrative discretion has for long been debated, and there is substantial work by EU administrative law scholars that has shaped significantly the contours of discretion in EU law, even if the institutional framework of the Union does not always allow for a strict reproduction of national concepts, and is notably also constrained by the Moroni doctrine on the delegation of powers. In practice, the SSM regulation empowers the ECB to exercise judgment in pursuit of its supervisory responsibilities. And I would say rightly so. Supervision is not a purely mechanical activity or a rigid application of legal norms. It relies on technical expertise, on experience, on forward-looking assessments, and on complex judgments. Effective and efficient supervision therefore requires a margin of technical discretion. And this margin of discretion must be respected unless the ECB commits a manifest error of assessment or exercises its powers unlawfully, for example, by exceeding its mandate or failing to observe essential procedural guarantees. These guarantees include, of course, inter alia, the duty to carefully and impartially examine all relevant factors and to provide an adequate statement of reasons. A manifest error of assessment should be understood in the light of the judicial standard of review, as we have just heard. And now to quote also again the opinion of Advocate General Emiliou, and I will quote, "The concept of standard of review refers generally to the intensity of review that courts must exercise when reviewing the lawfulness of the challenge acts. Approached from another angle, the standard of review corresponds to the degree of deference accorded by courts to the bodies which adopted the challenge acts." End of quotation. The EU standard of review thus revolves around deference to technical discretion, subject to clear limits, as I said. EU courts do not perform a de novo assessment. Rather, they perform a review of legality of the challenge acts against the relevant procedures and substantive rules. They verify whether the evidence is accurate, reliable, consistent, and sufficient to support conclusions drawn, while ensuring that procedural safeguards are respected. The courts refrain, however, from substituting their own assessment for that of the ECB. Put differently, the EU judges refrain from setting out what would have been, in their view, the best course of action for the institution concerned, considering the specificities of the case at hand. This is also the standard followed by the court in reviewing ECB acts adopted in the exercise of supervisory discretion. And as was expressly asserted by the court in the judgment in Crédit Lyonnais, and I quote again, "Insofar as the ECB has a broad discretion, the judicial review which the courts of the European Union must carry out of the merits on the grounds of a decision, such as the decision at issue, and I stress here, must not lead them to substitute their own assessment for that of the ECB, but seeks to ascertain that that decision is not based on materially incorrect facts or that it is not vitiated by a manifest error of assessment or misuse of powers. End of quotation. And with this, I think this serves as a useful bridge to the US judicial standard of review, which has traditionally leaned towards judicial deference to administrative discretion exercised by independent agencies, albeit subject to certain limits. Following the expansion of federal agencies during the New Deal, Congress enacted the Administrative Procedure Act in '46 to establish procedures for agency rulemaking and adjudication. Under the APA, courts were required to defer to agencies unless their actions were arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law. Courts also had to accept agency factual findings unless unsupported by substantial evidence. This standard that was enshrined in the statute actually somehow already reflected what had been the standard, the judicial standard laid down 2 years before in Skidmore, where the Supreme Court had already made clear that judicial deference, not being automatic, would have to rest on the consideration of the persuasiveness of an agency's reasoning, the thoroughness evident in its consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all these factors which give it power to persuade. This was the so-called Skidmore deference, which still remains relevant, embodying the principle of what is called the persuasive rather than the binding deference. In Chevron, which was delivered in '84, the court fundamentally reshaped this doctrine. It required courts to defer to an agency's reasonable interpretation of an ambiguous statute that it administers. The now famous two-step framework introduced by the Supreme Court in Chevron asks first whether Congress had spoken directly to the issue, and if not, and if the statute was ambiguous, then the agency's interpretation would prevail if deemed reasonable. I stress here, if deemed reasonable. So for 4 decades, Chevron cemented agency discretion in statutory interpretation. Yet, already in this century, the doctrine began to fray. In Mad Corporation, delivered in 2001, the court clarified that Chevron deference does not apply across the board, only when Congress has clearly delegated to the agency the authority to issue rules with the force of law. Otherwise, agency interpretations were entitled merely to the Skidmore's more modest persuasive weight. And this significantly narrowed the reach of Chevron, limiting it to cases where Congress had unmistakably entrusted lawmaking authority to an agency. In addition, the court had also developed in '97 the Howard deference, which was a deference standard to the reasonable interpretation of the agency's own regulations, on the assumption that the agency was best placed to clarify regulatory ambiguities. Now, in 2019, in the case in Kisser, a further retrenchment came in which the court reconsidered this Howard deference standard. And although it had not declined explicit that standard, the Howard case law, it sharply constrained its use. For the court, the Supreme Court, with Kisser, courts must exhaust all traditional tools of construction before deferring, and only grant deference when the regulation is genuinely ambiguous, the interpretation is reasonable, and the agency demonstrates expertise, consistency, and fairness. Kisser thus reflected growing judicial skepticism towards broad administrative leeway. But the decisive break came last year with Loper Bright. The court overruled explicitly Chevron, holding that the APA, so the Administrative Procedure Act, requires courts to exercise their independent judgment in interpreting statutes. Judges may not defer to agency interpretations simply because a statute is ambiguous. Ambiguity, the court reasoned, is not a delegation of power to agencies, but a call for courts to resolve the legal question. At the same time, the court still emphasized that its ruling does not preclude all forms of respect for agency expertise. Courts may still give weight to agency fact-finding, technical assessments, or determinations explicitly delegated by Congress, notably in the field of policy making. So let me bring together this, in coming to the end, this brief transatlantic tour with a few candid reflections. Broad discretion in the exercise of supervisory powers should be regarded as a cornerstone of independence. But independence must be counterbalanced by accountability and judicial review. Judicial review, however, should follow a differential standard when discretion involves technical or expert judgment. It is thus not sufficient, in order to establish a manifesto of assessment, for the judges merely to take a different opinion to that of the institution responsible for the action under review. This is precisely because technical discretion entails choices which are permitted by law, notably when EU institutions are giving discretion when applying the open-textured legal concept in individual cases, enabling, for instance, prospective analysis, which necessarily rests on value judgments or empirical assessments. Again, and as Advocate General Emiliou stressed in his opinion in lyonnais, there is a constitutional reason against full judicial review of discretionary choices. The power to make those choices has been entrusted to an institution other than the court. Too intrusive a review risks undermining the principle of conferral of powers to the institutions and disturbing the principle of institutional balance. In the US, however, the debate seems now framed in terms of separation of strict separation of powers between the executive and the judicial. The overruling of Chevron appears to curtail the interpretative authority of agencies on separation of powers, reaffirming that courts, not agencies, decide questions of law. I must say, however, that in reading some of the comments that have been made to this case law, there was one which I find very balanced in terms of its analysis, which was by Professor Thomas Merrill from Harvard, who identified that the long-term effects of Chevron might be a bit more nuanced, because the court's insistence on judicial independence may still leave space for agencies' expertise to be respected under Skidmore or in contexts where statutes confer discretionary authority. Whether Loper Bright now ushers in an era of aggressive judicial intervention or a recalibrated balance between courts and agencies remains to be seen. So in concluding, what this transatlantic journey shows is that although both systems wrestle with the same dilemma, which is how far should discretion go and who should guard its limits, they resolve it in very different ways. It seems that the US, now through judicial supremacy anchored in a strict reading of separation of powers, in Europe, in the European Union, through institutional balance. Returning to banking supervision, I would argue that discretion is not a side element, but a cornerstone of effective oversight. It enables supervisors to look beyond mechanical compliance and to confront risks that are emerging, uncertain, or qualitative in nature. For the ECB, this means that supervisors must be empowered to make risk-based judgments, particularly through qualitative measures on governance, internal controls, and risk culture, just to name a few areas. These judgments require discretion, escalation, and where necessary, enforcement. Yet, discretion can only command trust if it is exercised within a framework of accountability and subject to judicial scrutiny that respects institutional balance. In Europe, that means judicial deference to the ECB's technical expertise, paired with strong procedural safeguards and the assurance of legality. Supervisory discretion, when paired with accountability and a commensurate standard of judicial review, forms the bridge between independence and the rule of law. Thank you very much.
Thank you very much, Pedro. And then without further ado, Professor Emiliou, please. Somebody's going to help you with the slides, I hope.
Hopefully. Yeah.
Maybe you just say, next slide.
I could.
Would it be possible so that we can also see it there? Or? Oh, we're waiting on it. Okay.
Oh, they need to also be shared online. Yeah. Exactly. Yes. Okay. Technology is assisting us fully. Yes. And I should see there. No.
There's no way to make it visible there? Present it?
No.
You work with your own.
Yeah, this has been changed in the meantime, but while I maybe wait, but well, I can slowly make a start by thanking the organizers for having me, and especially Chiara for this very kind invitation. My task here is to try to bridge the two perspectives, which largely means I will repeat what has been said before, which will probably be very boring for all of you, but as the Latin said, repetita juvant. So hopefully, at the end of this panel, we will all have understood better something which I find still very sticky to kind of grapple with. And I think that the gist of my talk will be that, well, as Shakespeare used to say, what's in a name? So manifest error of assessment, deference can mean very different things to different people, to different legal systems, and also in different policy areas. So you see here on the slides, there is not just me, there is also Professor Orenta Mir, who is a professor of administrative law in the University of Arizona, who has co-authored this presentation with me. So what I want to do today basically is to say something about, in comparative terms, about the past, in that, as Pedro just mentioned, how the situation comparatively between the US and the EU used to be until Loper Bright, what changed with the Loper Bright case law, and then, speculate a little bit what the future might bring. So to go back to a bit both what Advocate General Emiliou and Pedro Machado have mentioned so far. If we compare the US and the EU approach, in the US up until the overruling of Chevron, the starting point was that courts defer to agencies' proposed interpretation of statutes conferring them powers. So as such, that also should be underlined, not any statute, but statutes that concern the powers that are conferred to them under two conditions: if these statutes were ambiguous, and if courts would deem the proposed interpretation as reasonable, as we have just heard. So Chevron deference is very much a deference on legal interpretation. Now, as we have heard from Advocate General Emiliou, there is no deference on legal interpretation in the EU. And now it's the second time I quote a Latin maxim. You should guess I'm Italian, or just from the accent. Jura novit curia. So courts are the only responsible for the legal interpretation. When it comes then to a second step, that's a step of the application of the law, the subdivision that Advocate General Emiliou has just explained to us between political discretion, larger deference, and technical discretion brings us to what is more relevant for our discussion today, which is the notion of technical discretion, and specifically the one that involves complex technical or economic assessment. And here you have, since a long time, this very, by now, standing case law and the standing formula of decisions are reviewable only against manifest error of assessment. So here I think the first difference with the Chevron deference emerges because manifest error of assessment, to me, or the deference in respect to technical choices of the European administration is not really a doctrine about legal interpretation, but it is about the courts tolerating a range of reasonable, factual, or evaluative judgments, as we have just heard, in situations of uncertainty, when certain value judgments have to be made, where certain modelings are perhaps needed.